All right, for some time now, criminal defense attorneys and DUI defense attorneys have grown to be considered two different breeds, two different types of lawyers, while both criminal lawyers not really speaking the same language and employing the same principles. DUI defense got so specialized in the late 80s when one local Broward County criminal defense attorney decided to really start tearing them apart, exposing the constitutional issues involved and all of the other things that make this type of law so colorful and interesting. I mean, it really embodies a little bit of every type of case. Well, I'm talking heavy cases too. I'm talking about the drug trafficking cases. But there's double jeopardy issues. The DMV and the states prosecuting you. You have engineering with intoxilizer devices, blood testing equipment, and let's not forget the chemistry and the biology along with that as well. You have the constitutional issues pertaining to an automobile that are different than clothing, just as they're different than the expectation of privacy that you've got in a house. You have the administrative process and the criminal state process. You have different standards of proof. You have an erosion of our constitutional rights because a machine can convict you, while every other element of every other crime must be proved by a prosecutor beyond and to the exclusion of any and all reasonable doubt. If an intoxilizer 8000 by CMI spits out a number of 0.08 or above, you are to presume that the defendant was impaired by alcohol. Well, if you really think about that, that means jurors, you don't really have to hold the state to the same standard. So we try to find a way to scrutinize these intoxilizers. We try to find a way to weed through all the nuances, complexities, and deadlines associated with defending DUI in Broward and Palm Beach County. If you're not up for it, you cannot take these cases on because the people that hire you are not employed, are not hired hardened criminals. Hardened criminals are easy, tough as nails. These are people that made a mistake, didn't think that they were going to get caught, more likely. And they don't want to deal with the consequences. And the fact that DUI is a politically charged crime motivated by private industry and the emotions of the public, especially following all of the lobbying and enduring the pressure that was put on against Mothers Against Drunk Driving and Mothers Against Destructive Decisions, all of which are getting DUIs now, or were a few years ago, made it so that the judges have room to help people out. I mean, a county's going to help you out with your DUI by way of a diversion, like Miami does, when they lose control of their docket. For years, Miami had no control over their docket, and 90% of DUIs got dismissed in Miami for doing nothing. But for skilled criminal defense attorneys that spent some time learning the art of DUI defense, this made it difficult in the outer counties like Broward, or the Tri-County area, Broward County and Palm Beach County, for defendants that all heard, well, I know 5 people that have gotten their cases dismissed. Because you come from Miami, where they couldn't even prosecute a DUI to save their life, to where they now have a diversion program You cross over the county line to Mike Satz's territory, and they aren't breaking down anything. They're not breaking anything down, unless if you're skilled and the prosecutor gets scared or the prosecutor doubts their case or has too many cases. Had a long weekend, and they can somehow break the case down. Your client's in a bind unless if they're prepared to plead to minimums. So if you're going to try these things, if you're going to take these cases on, you better be good at them. If you're not good at them, you work at them with someone who's an ace at these things. And you do it because it's going to make you better at every other aspect of your criminal defense practice as it pertains to other crimes. If you really tear these things apart, you will have done more work with electronic surveillance than the prosecutor seeking to convict your client for drug trafficking, who they were monitoring. There's electronic surveillance in DUIs, aren't there? Okay. I know I'm moving all around here, but a couple of things that I wanted to point out. You're going to hear, if you go to seminars and lectures, if you go to the big DUI seminar in Las Vegas in October, you're going to hear hours of yap about how you've got to raise the issue of double jeopardy because a defendant's being charged by the state and the DMV is trying to take their license away. Don't be ridiculous. Okay, it was clever when somebody came up with it 15 years ago. It didn't work. It's not going to work. Don't try to renew that one. Radio frequency interference. I can't believe that so-called DUI attorneys in Florida were preaching about this. The idea that if an officer was near the intoxilizer when it was being used, and this was the 5000 at the time, the CMI 5000, that if the radio went off, then it could interfere with the intoxilizer and send a faulty result. Yes, you can get an expert to come in and testify to radio frequency interference. No one's going to buy it. I honestly don't even know if I can tell you a bunch of judges that won't allow that evidence in. All right, ambient air. The argument that what you clean the room with can affect the intoxilizer results because a lot of cleaners are made with chemicals. Whatever. Don't argue it. Arguments that a defendant's demeanor or the way that a defendant carried himself or herself when exiting the vehicle, they grabbed the door because they needed something to hold to maintain balance. If a jury, the right jury, if you've done the right job and you've picked the right jury is going to understand, if you've picked the right jury, those people are going to understand, well, I think the defendant was probably drinking, but I can say, I know why. Of course, they can't come up here and say, yeah, I'm guilty of DUI. And so they're going to allow a little wiggle room for being silent or not wanting to take the heat and be convicted of DUI. But if you appear to be lying to the jury, you guys are both done. You're both done. So don't lie to the jury. Don't fight things that are clearly signs of impairment. One of the things that I have always been fascinated by, and it is just it really gives you hope in even the worst DUIs, first and second DUIs. It's this. No matter what happens, I bet that officer is going to overreach and exaggerate the cues and symptoms and indicators of impairment. And if I set this up right and I ask the jurors in voir dire to each give me a cue or something that they would describe as being an indicator that somebody is under the influence of alcohol or drugs, and I'm sitting there with 16 different cues, well, I think when somebody's impaired, they sway. I think that when somebody's impaired, they have red eyes. Well, I think that they are belligerent. Well, I think that they don't follow instructions. Well, I think that in closing, when you look at this jury and you can tell them that even though you haven't spoken, because you can't speak to jurors during a trial, even though you haven't spoken, I heard you, Miss Jacobs, juror number 2, when that video went in. It wasn't long before you thought to yourself, wow, what I'm seeing on this video doesn't match up to the exaggerations that the police officer seemed to make. But I don't want them, and don't even let jurors begin to worry about a police officer. You make it real clear to them, no police officer's getting in trouble. No one's being accused on law enforcement. This case about a year old. That officer was doing his or her job, and we appreciate the service, but everybody is capable of making mistakes, even in an opinion crime like DUI, and this wasn't the person that the officer described. You all had a window to the night of the arrest. All right.